Every video you have ever seen about international law does the same thing. It gives you a list. Here is the United Nations. Here is the International Criminal Court. Here are the Geneva Conventions, names, dates, institutions, and by minute 3, you have already forgotten minute 1. Because lists do not teach you how something works. They teach you how something is labeled. This video does something different. In the next 20 minutes, you are going to understand the single invisible engine that makes the entire international legal system run. Not the names, not the dates, the mechanism, the one idea that explains why countries follow rules when nobody can force them, why some treaties get broken and nothing happens while others cannot be broken by anyone on earth, and why the most powerful legal system in human history was built without a single police officer. No other video on this topic will show you this. This one will. You are watching the news. A country committed what every journalist on screen was calling a war crime. Civilians killed, buildings flattened, footage so clear there was no debate about what happened, and then nothing. No arrest, no trial, no police showing up at the border with handcuffs. You waited a day, a week, a month. The story moved down the page, got replaced by something else, and the country that did it kept doing whatever it wanted. And somewhere in the back of your head, a small voice asked the obvious question, who is supposed to stop this? You looked it up. You found the United Nations. You found something called the International Criminal Court. You found treaties with long names. And after 30 minutes of reading, you were more confused than when you started. Because nothing you found sounded like actual law. It sounded like suggestions. Strongly worded letters, agreements that countries could ignore whenever ignoring was more convenient than following. So you came to the conclusion most people come to. International law is not real law. It is a performance. Countries pretend to follow rules and then do whatever they want. That conclusion is wrong. But the reason you reached it is not your fault. Nobody ever explained to you what international law actually is, how it actually works, and why it works completely differently from every other kind of law you have ever encountered. They gave you the vocabulary without the mechanism. They told you the names of the institutions without explaining the engine that makes those institutions run. And without the engine, it all looks like theater. That stops today. By the end of this video, you will understand international law the way it actually works, not as a fantasy of world government, not as a cynical joke, as a real system with a real logic that explains exactly why some rules get followed, some get broken, and some are so deep that breaking them costs a country its place at the table. No jargon, no legalese, just the real idea, the way it should have been taught the first time. And here is the truth that makes all of it click. Everything in international law comes down to 2 questions. First, how can law work between countries when there is no police? And second, why do countries follow rules they do not have to follow? Those 2 questions have answers. The first answer is called treaties. The second is called customary international law. You will understand both by the end of this video. But before we can get there, you need to see the world those answers were built for. Imagine 20 neighbors living on the same block. Each one is armed. Each one owns their house completely. There is no police station on the block, no courthouse, no mayor, no homeowners association. Each neighbor is the absolute king of their own property. They can build whatever they want, play music as loud as they want, paint their house whatever color they want. Nobody can tell them otherwise. Now what happens when 2 of them disagree? Neighbor A says neighbor B's tree is dropping leaves on his lawn. Neighbor B says it is his tree and he will do what he wants. There is no one to call, no judge to decide, no officer to enforce. The only options are talk it out, ignore it, or fight. And if they fight, nobody stops them. Nobody steps in because nobody has the authority to step in. Everyone is sovereign on their own land. Now multiply that by every dispute that could ever happen between 20 armed, independent, sovereign homeowners. Property lines, noise, water runoff, shared roads, stolen tools, broken fences. Every single conflict goes through the same three options: negotiate, ignore, or fight. And the bigger the neighbor, the more fights they tend to win. Not because they are right, because they are bigger. That block is planet Earth. Those 20 neighbors are countries. And that situation, that total absence of authority above the parties, is what political scientists call anarchy. Not chaos, not disorder, just the simple structural fact that there is no government above governments, no world police, no global court with the power to drag a country in against its will, no president of the planet. Every kind of law you have ever experienced works because somewhere, somehow, there is a force that can make you comply. Domestic law has police, police have courts behind them, courts have prisons behind them. The whole chain ends in a force you cannot resist. International law does not have that chain. There is no final force, and that is the puzzle. That is the problem that international law was invented to solve. How do you build something that looks like law, works like law, and creates real obligations in a world where nobody can force anybody to do anything? The answer starts with one idea, one foundation. If you do not understand this idea, nothing else in international law will ever make sense. But if you do understand it, everything falls into place. The idea is called sovereign consent. In plain language, it means this: no country is bound by any rule it did not agree to. Period. There is no exception to this. There is no workaround. The entire architecture of international law is built on a single, unshakable premise. The only reason a country follows a rule is that at some point in some way, that country chose to follow it. Think of it like a poker table. Nobody is forced to sit down. The chairs are open, the game is running, but nobody can drag you to the table, put chips in front of you and force you to play. However, once you sit down voluntarily, once you pick up your cards and push your chips into the center, the bet is real. The chips you wagered count. You cannot take them back just because you do not like the hand. You chose to play. The consequences of playing are now yours. That is sovereign consent. Every treaty a country signs, every international organization a country joins, every rule a country follows on the world stage exists because that country, at some point, said yes. And the reverse is equally true. If a country never said yes, the rule does not apply to it. The United States is not bound by treaties it did not ratify. China is not bound by agreements it did not sign. No country is, because in a world with no police above nations, the only authority that exists is the authority each nation gave to itself. This might sound like a weakness. It is not. It is the engine. Sovereign consent is the only reason international law works at all. Because the alternative, a system where someone imposes rules on sovereign countries without their agreement, would require a force more powerful than every country on Earth. That force does not exist. So the system was built on the only foundation that could actually hold: choice. Countries follow the rules because they chose the rules, and that choice is where everything begins. Now that you have the foundation, the two tools are easy. Here is what treaties do. A treaty is the first answer to the first question: how can law work between countries when there is no police? The answer is, countries write their own rules, together, voluntarily, and then hold each other to them. A treaty is sovereign consent made explicit, written down, signed, ratified, stored in an archive. It is two or more countries sitting at a table, negotiating what they will and will not do, and then formalizing that agreement into a document that both sides treat as binding. But here is what most people do not realize. A treaty does not just appear. It goes through a specific process, and each step matters. First comes negotiation. Diplomats from the involved countries meet, sometimes for years, and argue about every word. This is not ceremony. The wording of a treaty is the law itself, so every comma matters. Second comes signature. When the negotiators agree, representatives of each country sign the document. But signing is not the end. In the United States, a signed treaty means almost nothing until it passes the third step, ratification. Ratification means the treaty goes to the Senate, and 2/3 of senators present must vote yes. Only then does the treaty become binding on the United States. This is why you will sometimes hear that a president signed a treaty, but the country never ratified it. Signing is the handshake. Ratification is the commitment. Now imagine a country signs and ratifies a treaty and then breaks it. What happens? This is where international law looks strange compared to domestic law. There is no police to arrest the country. There is no prison to put it in. But that does not mean nothing happens. When a country breaks a treaty, 3 things occur. First, the other parties to the treaty can suspend their own obligations. If you promise to trade with me and I promise to trade with you and you stop, I can stop too. Second, the breaking country's reputation takes damage, and reputation in international relations is not abstract. It is the currency of future deals. Every country considering signing a future treaty with the violator now has evidence that this country does not keep its word. Third, other countries can impose consequences, sanctions, diplomatic isolation, exclusion from organizations. None of these require a police force. They require coordination. And coordination is what treaties are designed to produce. Think of a treaty like a message that 2 countries write together, sign and lock in a drawer. If one country opens the drawer and tears up the paper is gone. But the entire world watched it happen. And next time that country wants to make a deal, everyone remembers the torn paper. Treaties also come in different sizes. Bilateral treaties involve 2 countries. A trade agreement between the United States and Japan, for example. Multilateral treaties involve dozens or even hundreds. The Geneva Conventions, which set the rules of war, have been ratified by nearly every country on Earth. And organizations like the United Nations exist not as governments above countries, but as platforms where treaty-making can happen more efficiently. The United Nations does not make law. It creates a room where countries can sit together and make law themselves. Now here is the second tool. If treaties are the explicit side of international law, customary international law is the implicit side. And it answers the second question. Why do countries follow rules they never actually signed? Because some rules do not need a treaty. Some rules became law simply because every country in the world started following them for so long and with such consistency that eventually the practice itself hardened into obligation. That process has a name. It is called customary international law, and it works like this. Picture a supermarket. There is no sign on the wall that says, "Form a single line and wait your turn." There is no contract you sign at the door, but every single person in that store stands in line. They do it because everyone else does it. They do it because they believe they are supposed to. And if someone cuts the line, every person in that store knows something was violated, even though no one can point to a written rule. Customary international law works the same way. 2 things must be true for a practice to become customary law. First, countries must actually do it consistently over time. This is called state practice. Second, countries must do it because they believe they are legally obligated to do it, not just because it is convenient. This second element has a Latin name, opinio juris, which simply means a sense of legal obligation. When you combine widespread, consistent practice with a genuine belief that the practice is required by law, you get a new rule of international law, no treaty necessary, no signature required. Here is where it gets powerful. Some customs have hardened so completely that they have become what international lawyers call jus cogens, or peremptory norms. These are rules so fundamental that no country can opt out of them, ever, regardless of consent. The prohibition against genocide is one. The prohibition against torture is another. The ban on slavery is another. These norms sit at the top of the international legal order. A treaty that violates a peremptory norm is automatically void. Not voidable, void, as if it never existed. And then there are the courts. The International Court of Justice, which sits in The Hague, resolves disputes between countries. But here is the catch. It can only hear a case if the countries involved agree to let it. Sovereign consent again. The International Criminal Court is different. It prosecutes individuals, not countries, for the most serious crimes: genocide, crimes against humanity, war crimes. But its reach is also limited to countries that accepted its jurisdiction or situations referred to it by the United Nations Security Council. Even international courts operate inside the architecture of consent. So customary international law and treaties look completely different on the surface. One is written, the other is unwritten. One requires a signature. The other requires a pattern. One lives in archives, the other lives in behavior. They seem like two separate systems running on two separate tracks. Here is the part most people never see. They are not two separate systems. They are the same system. Treaties are consent made explicit. Custom is consent made implicit. But both of them are consent. Every treaty is a country saying, "I agree to this rule," out loud, in writing, with a signature. Every custom is a country saying, "I agree to this rule," silently, through decades of consistent behavior. The mechanism is identical, the volume is different, and once you see that, the whole field reorganizes in your mind. International law is not a collection of random agreements and vague traditions. It is one single question asked over and over: what did you consent to? If you signed it, you consented explicitly. If you practiced it long enough and believed you were obligated, you consented implicitly. And in the rare cases of peremptory norms, the consent of the entire human community has hardened to the point where opting out is no longer an option, because some lines are so fundamental that crossing them puts you outside the community entirely. Power and law in the international system are not opposite forces. They are the same force. A country's power determines how much it can shape the rules, but the rules, once shaped, bind even the powerful. Not because someone forces compliance, because the cost of breaking consent, the torn treaties, the lost reputation, the sanctions, the isolation, is higher than the cost of following it. The system works not despite the absence of police, but because of it. The absence of a central enforcer forced humanity to build something more creative, a system where every participant is simultaneously the rule maker, the rule follower, and the enforcer. The whole thing runs on mutual vulnerability, and that is the most remarkable legal invention in human history. Once you see this, you cannot unsee it. Here is what most people get wrong about international law. The first mistake is thinking there is a world police force somewhere that is supposed to be enforcing all of this. There is not. There never was. Enforcement in international law is horizontal, not vertical. Countries enforce against each other through pressure, through sanctions, through reputation costs, through alliances. No one enforces from above. The second mistake is thinking the United Nations is a world government. It is not. The United Nations is a platform, a stage, a meeting room. It has no army of its own, no legislature that passes binding laws on countries, no court that can drag nations in without permission. It is the table where the poker game happens. It is not the dealer. The third mistake is the most important one. People see a country violate international law and conclude that international law does not work. But domestic law gets violated every single day. People steal, assault, defraud, and break contracts constantly. Nobody says domestic law does not exist because crimes happen. Violation is not evidence of non-existence. It is evidence that the system is under stress. International law works the same way. The fact that countries sometimes break rules does not mean the rules are fake. It means the rules are being tested, and the system's response, slow, imperfect, but real, is where the law actually lives. The fourth mistake is confusing two very different courts. The International Court of Justice resolves disputes between countries. If country A says country B violated a treaty, they can take the case to the International Court of Justice, but only if both countries agree. The International Criminal Court is entirely different. It prosecutes individual human beings for genocide, crimes against humanity and war crimes. Different court, different jurisdiction, different purpose. Mixing them up makes the whole system look incoherent when it is actually two tools built for two completely different jobs. Let me show you exactly how this knowledge is useful right now. Next time you read a headline that says, "A country violated international law," you now know to ask the right question. Which law? A treaty. Which treaty? Did that country ratify it? Or is it a customary norm? How widespread is the practice? Is it a peremptory norm that no country can opt out of? That single question, which law, transforms a vague headline into something you can actually analyze. When you hear about sanctions, you now understand what they really are, not punishment from above. A group of countries voluntarily deciding together to stop trading with, lending to, or cooperating with another country. Sanctions are horizontal enforcement in action. They are countries using their own sovereignty to pressure another country's sovereignty. When someone says, the United Nations should do something, you can now identify what that really means. It means member states, through the Security Council, need to agree on a course of action, and that agreement requires the consent of 5 permanent members, any one of whom can veto. The United Nations does not act. Its members act through it, and every situation depends on specific treaties, specific states, and specific facts. What you just learned is the framework, not the answer to any particular case. Here is what you now know. International law is a real system built on a real foundation. That foundation is sovereign consent, the idea that no country is bound by rules it did not agree to. 2 tools sit on top of that foundation: treaties, which are consent made explicit, written, signed, and ratified, and customary international law, which is consent made implicit, practiced, believed, and eventually hardened into obligation. The first practically useful idea is this: international law works without police because it was designed to work without police. Enforcement is horizontal. Countries hold each other accountable through pressure, reputation, and coordination, not through a central authority. The second is this: every question about international law becomes clearer when you ask, who consented to what? That single question is the key to every treaty, every custom, every institution, and every dispute. And the third, the one that holds the whole thing together, is this: treaties and customary law are not 2 separate systems. They are the same force, consent expressed in 2 different ways. One is loud, one is quiet, but both are binding. And when consent runs deep enough, it becomes peremptory, a norm so fundamental that no one can opt out, because the entire human community has already decided. You started this video watching a country break a rule and seeing nothing happen. Now you know that something was happening, quietly, through reputation, through alliances shifting, through the slow, grinding machinery of a system that was never designed to look like domestic law because it was never supposed to. The law between nations does not have a siren, but it has a consequence, and that consequence is the only thing holding the world together. This is education, not legal advice. If you face a real situation involving international law, talk to a licensed attorney in your jurisdiction.